I now call the fifth case on this morning's docket, which is case number 117512 in the care and treatment of Clay Robert Snyder.
May it please the court. My name is Mary Curtis. I'm here on behalf of Clay Snyder, who was charged in 2012 in a criminal case in Saline County, Kansas. Mr. Snyder has a very low IQ, what is termed an intellectual disability. Because of that, Saline County began a prolonged inquiry into whether he was competent to stand trial. Finally, in 2017, the court found he was not competent. This is Saline County. Found he was not competent and unlikely to become competent in the foreseeable future. The court at that point, by statute, had two options. It could dismiss the criminal charges or order the state to initiate involuntary civil commitment proceedings, and it did the latter. The involuntary civil commitment case was filed in Pawnee County District Court, which is where Larned State Hospital is located. Mr. Snyder was located at Larned. A hearing was held in March of 2017, and the Pawnee County District Court found Mr. Snyder to be a mentally ill person subject to involuntary civil commitment and ordered him confined at Larned for the indefinite future for treatment. This appeal followed. And this court has asked that we address a show cause order, why this should not be consolidated with the next case on the docket, which is a habeas proceeding. And this is an appeal from a decision in a civil, involuntary civil commitment case. It's made by a different court, Pawnee County, than the decisions that are being questioned and challenged in the habeas petition. Those decisions were made by the Saline County Court. This case has its own unique issues. Certainly we don't intend to waive any of the issues that Mr. Snyder presented in his habeas. But these issues presented by this appeal are separate and distinct. They concern...
Kind of, sort of separate and distinct, but when you're talking about the definition of a mentally ill person, it's different if there wasn't the competency hearing, right? Under the competency statutes, a mentally ill person can be a person who commits one of those crimes.
Yes, and the habeas, as I understand it, and that'll be argued by someone else other than me, challenges
whether there's sufficient evidence to support his commitment involuntarily in this case will depend upon whether he meets the definition of a mentally ill person, right?
Yes.
And
that determination was made by Pawnee County
But that
District
definition,
Court.
do you use the regular Chapter 59 definition? Is that all that's used here? Because the competency sends you to these proceedings and defines mentally ill differently than Chapter 59.
Yes. Yes.
And so they aren't divorced. I mean, the fact that the competency hearings took place impact what the Pawnee County District Court had to decide.
No, I disagree.
Okay.
The Pawnee County District Court is presented with an entire new case. It is divorced, to use your word, from the criminal case. And the question in the Pawnee County District Court was whether, and it's a new due process hearing with new due process guarantees. The question is whether he is a mentally ill person who should be confined involuntarily for treatment. And there's a whole Supreme Court line of cases about when someone can be involuntarily civilly committed. Those standards, and that's actually what I hope to address in my argument, those standards are unique to the civil commitment arena. And competency is a different issue. And the decisions made in Saline County on competency were, as you pointed out, using different standards as to
Let me see
what's
if I can
competence.
get to it at the same point a different way. The habeas proceeding is a restraint on Mr. Snyder's liberty. That's what we're trying to, his liberty is restrained. That's the allegation, okay? His liberty is being restrained in part because of the civil commitment proceeding. The definitions that let the civil court commit him add, because of the criminal proceeding, mental retardation. That's the whole argument you make, that there's mental retardation and it shouldn't be a factor in the civil commitment process. Well, the reason that the reason the statute gives, regardless of whether it's constitutional or not, the reason the statute gives is because there's these charges out, these criminal charges out there. And so the criminal charges are being used, at least it seems possible to me, that the criminal charges are being used as a restraint on his liberty because that qualifies him for a different path in the analysis of the civil commitment. So why wouldn't we want to put these two things together so that we can follow that path consistently? Does that make sense to you?
You might want to do that. I disagree. If you wanted to consolidate this care and treatment case, I would suggest you consolidate it with a bunch of that I have in the pipeline, where people are being involuntarily civilly committed after findings of not competence. They do not have a mental illness. That is an identity of issues. That could be, all those appeals could be consolidated and disposed of with a single decision, finding that the Care and Treatment Act is unconstitutional.
That seems to me to mean that you're more focused on this global policy issue as opposed to the issues that directly affect Mr. Snyder. I'm looking at Mr. Snyder's restraint. He's been in confinement for a very long time.
Yes.
And trying to get to the bottom of that is why we're interested.
Yes.
And it just seems to me that this restraint on liberty that is permitted to have a different threshold because of the criminal charges makes this all relevant for him.
There's no question that this involuntary civil commitment has resulted in him being confined for another year, after it seems clear that the Saline County Court had run out of reasons to continue to confine him. So yes, I agree that this all has to do with whether or not he's in confinement. But the issues in the habeas concern just the overall lack of due process and speedy trial, and the decisions made by a different court
Counsel,
in a criminal case.
Can I move you off of the consolidation question? 'Cause I think your position's clear on that, or at least to me it is.
Sure.
And just zero in on your case.
I would like to make my argument.
Whether or not we consolidate or not, let's leave that aside for the moment at least, and ask about your case in particular, the care and treatment case.
Sure.
Is it your allegation that the statute was violated by the district court, Or are you suggesting that the statutory procedure that was followed by the district court is constitutionally infirm?
The latter, and that's because it.
So you don't dispute that, you're not making an argument that under the statutory scheme, this was improper?
Well, the court, I think, had the option, having no evidence of mental illness and no evidence of dangerousness before it. I think the court still had the option to
Well, were they,
not find that he should be involved.
was the court required to not find?
Okay, there's too many negatives in that series of exchanges.
Are you making a lack of evidence argument? Are you saying the district court did not have sufficient evidence to make the finding that it made under the statute?
Yes, and I'm saying that that the statute is constitutionally infirm because it mandates the outcome that she reached, and she acknowledged in the transcript of that hearing that she was forced to come to the outcome that she came to by the statute.
Why? Why was she forced to come to the outcome?
Because the definition of mental illness in 592946F, which excludes organic mental disorders such as traumatic brain injury and intellectual disability, was modified by 223303 to include anything that might be wrong.
So now intellectual disability is now, it now qualifies, whereas for any other person it wouldn't qualify. But
that's correct.
My follow-up question is, the statute still requires the district court to make a factual finding of danger to self or others, doesn't it?
Yes. And
was that satisfied
she acknowledged that her finding of dangerousness was based solely on the charges that had been brought.
Are you challenging that ruling?
You mean,
that
should
finding.
she have, did she err by finding in the absence of evidence? Yes.
Okay.
And I think she knew, Judge Cowell knew, that that the outcome was determined.
Your argument is that the fact that an individual was charged with one of these crimes is not sufficient, standing alone, to satisfy the statutory requirement that the person be found to be dangerous.
Well, yeah, I think that's kind of obvious. I mean, I think he's entitled to the same presumption of innocence as anybody else.
So why isn't that sufficient?
That an allegation be brought, and the evidence that she heard was that he had shown no tendency to aggression or dangerousness in 5 years in custody. They'd had a little bit of time to observe him. That nothing in his diagnosis indicated that he would be dangerous or aggressive. That he had no convictions, and that the only evidence, and she acknowledged this, that she had before her that might indicate that he was dangerous was that somebody in another county had made an allegation, and the prosecutor had filed charges. He never even had a preliminary hearing. So we don't know, and she didn't know when she made her ruling, whether he committed those crimes. And using an allegation as evidence of dangerousness, I would say, is akin to the prosecutor standing up in front of a jury announcing what they've charged the defendant with and saying, well, you jury, you can go ahead and go out and find him guilty, because I've told you what I've charged him with.
Well, as I remember the facts, the witness had also reviewed the nurse examiner's report
You know,
of the evidence on the victim. Am I right about that one?
In some of the reports, there is a rumor, is the best way to describe it, I think, that the psychologist may have reviewed another psychologist's report who had reviewed a affidavit of a prosecutor who had reviewed police officers' reports, who had maybe talked to the mother of the alleged victim. So, you know, that wouldn't stand up as evidence in a criminal case. And I don't think it should stand up as any indication of dangerousness in this case.
Counsel, staying on that point, assume we agree with you.
Sure.
This isn't a static case. There's a lot of water under the bridge since March. What do we do with that?
You review the decision that was made by the trial court at the time that she made the decision.
Is it mooted by the fact that we have new reports, in fact, multiple new reports that may conflict with one another? But I mean, this district court has continued to hear evidence, and that evidence, that evidentiary world, has continued to change. I'm just procedurally speaking, like, what do we do with that?
No, I think you review the decision that she made, just like you would when a prosecutor submits their case and goes to the jury and
Well,
the
if it's
decision
error,
is
what
made.
happens? What happens to the case? It's just
If you
dismissed.
find that she erred, you find that the statute's unconstitutional, and he's still in confinement,
well, what,
and he's
I thought we were
entitled
talking
to
about
a
the
new
evidence.
hearing on whether or not he should be in confinement. Does that not answer your question?
Well, not really, because that's what's happening now. I mean, he's continually being evaluated, and there are ongoing proceedings in
Yeah,
the
and-
district court.
And she has since found that he's neither mentally ill nor dangerous, and should have dismissed the case at that point, which would
As
have.
I understand it, the state came forward with additional reports, which now the district court has taken under advisement. I understand that
Yeah.
from your perspective,
That's
those
not
don't
that's
have
not in your
merit.
record.
And it's not, but it does give rise to my question, which is why isn't the March proceeding just sort of made moot by subsequent events?
Because he lost now a year of his life as a result of that decision. She could have dismissed the
But how do
petition.
we rectify that? The question is, what do we do today with that fact?
Well-
We can't give him the year back,
You can say it was wrong,
okay?
and you can say it was based on an unconstitutional statute, so it stops happening to
But why do we
everybody.
need to do that if it's insufficiency of the evidence of dangerousness? Why do we have a constitutional avoidance?
Because the statute mandates
Excuse
that.
me,
Counsel?
Counselor.
Oh, I'm sorry.
We have a constitutional avoidance. We decide a case on the least denominator, and if there was insufficiency of evidence of dangerousness, then there's error. Then we would find there was error, and my colleague's question is, what's the next line? Do we remand? Do we reverse? Order release? What is it that we do on the next line of our opinion?
And your question assumes that you
Assuming
that you
there's
find that there's
insufficient
nothing wrong
evidence.
with the statute. That
Well,
that
if
she
we-
just
Assume we find
Made
insufficient
an error.
evidence to support the district court's findings.
well, you dismiss ordering released. And you know, he still has criminal charges pending.
You
Find it was
understand their-
error.
You understand what they're suggesting, that we don't reach the constitutional issue, we just say there was insufficient evidence, then why would it be any different than a criminal case where we say there's insufficient evidence and we reverse outright and that's it? This proceeding ends. It wouldn't be any different, would it? That would be the remedy. And then whatever happens in the criminal case happens in the criminal case.
Yes, that's correct. And then by statute, because that's thrown back to Saline County, the prosecutor has to, within 14 days, ask for a new competency hearing, or dismiss the charges. So
Unless the state files a new care and treatment case based on the evidence that wasn't present in March. I guess I'm just very in terms of judicial economy and practicality, how do we not end up back where we started? Is there any way to avoid that from your perspective, short of throwing the statute out?
Well, that's why I think you have to throw the statute out, because I think it's pretty clear from her ruling and the comments that she made during that hearing that she will always make that ruling in the face of this evidence. And I've had a bunch of these cases and they're coming up. And she feels that she's constrained to make that ruling where someone is found not competent as a result of their low IQ is too low for them to ever be competent. She has to find them mentally
Do you
ill.
understand the difference between that issue, the intellectual disability versus mental illness issue? That's different from a finding of dangerousness. And a number of times you've sort of gone back and forth between the two. I understand your argument is that the statute's constitutionally infirm because it permits intellectually disabled people to be committed.
And
But we wouldn't have to reach that if we found there was insufficient evidence to support the dangerousness holding.
And I haven't started making my argument yet, the argument that I had prepared to make. But my argument is she didn't have grounds. The reason it's a due process violation is that she found both without having a basis for finding either, and that the statute dictates both findings. And that's what I've sort of been
Okay.
trying to get to. May I have a few minutes to address my argument?
You're out of time. I'll give you 60 seconds to wrap up.
Yeah. Okay, Jackson versus Indiana. He was confined without a compelling state interest being shown. That's in violation of the Constitution, due process, 5th and 14th Amendment guarantees. He was confined for treatment when it was known that there was no treatment that could address his mental disorder, and if he'd been charged with a lesser offense, his diagnosis would have excluded him from being confined. So it's an equal protection violation. She found he was not mentally ill, that he had no psychiatric disorders, that he was not dangerous, and that the statute compelled her decision. And because that was the inevitable result in this and all similar involuntary civil commitment hearings, the statute violates due process and equal protection.
Does that conclude your presentation?
Well, I'd like to go on.
Does that conclude your presentation during the time allotted?
Yes.
All right.
Thank you.
Do we have any questions of counsel before she goes back to her table? I see none. Thank you.
May it please the court, I'm Assistant Solicitor General Dwight Carswell, appearing on behalf of the state. Snyder's constitutional challenges to his commitment are all without merit. First of all, the Constitution allows the state to involuntarily commit dangerous individuals with mental disorders, even if they don't have a mental illness, as that term is understood by psychologists.
Counsel, let me just ask you, on what basis is the state of Kansas presently holding Mr. Snyder?
He has a mental disorder, intellectual disability, and is a danger.
And was there, I'm sorry, you go ahead.
Well, isn't the answer the civil commitment proceedings?
Oh, yes.
Okay.
I mean, pursuant to those proceedings, that's the constitutional basis is that he's dangerous and has a mental disorder.
And am I right that the criminal charges are a restraint on his liberty pursuant to that civil commitment proceeding because of those criminal charges, you get to talk about his mental retardation, his intellectual disability. You get to include him as being eligible for civil commitment, right?
Because he was charged in the past and was found to be incompetent, that triggers this particular definition. I don't think the fact that the charges are still pending restrains his liberty in any way. The fact that he was charged, yes, the fact that there was a criminal case and then he was found as part of that to be incompetent under the statute, then it says under the Care and Treatment Act.
It's
the
only because
definition
you've
of
got the
mental illness.
off-grid pending out there that you get to include a person with intellectual disabilities into the people that might be civilly committed.
I mean, I guess I would read the statute as saying even if the criminal charges get dismissed, the fact that he was charged and found to be incompetent, that's what triggers the special definition of mental illness here.
It's the criminal cases
It's the-
that gives you that, whether it's dismissed or still pending, but it was the allegation
Exactly.
of criminal off-grid conduct that gives you jurisdiction that would ordinarily not be there for any other citizen.
I would agree with that. I think what I maybe heard Justice Biles was saying was that the fact that there are still criminal charges pending, and I don't think it matters, as you indicated, whether it was pending or dismissed. I think the fact that there was criminal charges that meet the off-grid criteria.
You think that the state could civilly commit someone with an intellectual disability because 20 years ago they were charged with an off-grid felony?
If they were charged and then found to be incompetent at that point, the way the statute works is the district court orders KDADs to initiate commitment.
Right.
So
And that fact, so even after that,
this is a lifetime commitment for Mr. Snyder. It is. I mean,
Not necessarily.
if he was found charged of an off-grid felony, found incompetent, he's dangerous. He's dangerous. He fits your definition of what dangerousness would satisfy the statute to civilly commit him, and that would be it. Sounds like.
he can be held indefinitely if he continues to be dangerous. But if he's no longer dangerous, and the state has to periodically reprove dangerousness.
You're basing it on the allegation that was made, what, now 6 years ago?
I mean, that's not entirely true. It's based on the mental health expert's testimony. She did look at the charges, of course, and she interviewed Mr. Snyder. And,
Back in when this initial determination was made in March, what evidence did the district court rely on to support the finding of dangerousness?
the testimony of the mental health expert, Zogelman, I believe was her name. She testified that she reviewed the file, she interviewed Snyder, and she concluded in her expert opinion that he was dangerous, was likely to cause harm to self or others is the statutory term. So there was an expert's testimony and that was the basis of the district court's finding. Now that expert relied on, she looked at the charges, she looked at facts that were surrounding those charges, not just the charges themselves, but information.
I missed what you said besides looking at the charges.
Besides the charges, information relating to the charges, such as the information from the police reports that got put into prior
And
experts.
the expert did interview Mr. Snyder?
That's my understanding, yes. Because she testified that in interviewing him, he didn't seem to understand the seriousness of the charges, which was another basis for her conclusion. So that he was told that you're charged with raping a 4-year-old girl, and he didn't seem to understand that was a serious matter. And she said that raised a real concern that if released, he could do that again because he didn't realize it was serious.
There's never been a court determination that there's probable cause to believe that this person committed the acts for which he was charged, has there?
Not to my knowledge, no. I think the competency.
Thought there was a statutory requirement that if someone was incompetent to stand trial, that no, that's on the Sexually Violent Predator Act. You would have to prove that they did the act. But so you're saying that it's constitutional to commit someone under Chapter 59 based on an expert's interpretation or opinion as to whether certain acts represent dangerousness without any probable cause determination that this person committed those acts.
Well, it's based on the expert's testimony, but then the district court needs to find that testimony constitutes clear and convincing evidence of dangerousness. And the district court found that here. And I would note on appeal in his opening brief, Snyder did not raise the sufficiency of the evidence challenge. He just challenged the constitutionality of the statute. The word sufficiency of the evidence is nowhere in that opening brief. The standard for sufficiency of the evidence is not cited. So that issue isn't even before the court. His only argument was the statute doesn't require the state to prove dangerousness, and in fact it does. KSA 2233 specifically says the state has to prove that the person is likely to cause harm to self or others. So that argument is just not true, and the sufficiency of the evidence challenge is not before you. As to his claim about, Snyder's claim about mental illness, the identical claim was raised in Hendricks. The U.S. Supreme Court rejected that there. In fact, the petitioner in Hendricks, or excuse me, the respondent in Hendricks cited some of the same cases as Snyder. And the Supreme Court said, no, we've talked about mental illness in the past, but mental illness isn't required. And they cited their prior decision in Heller v. Doe, which involved mental retardation, now called intellectual disability. So Hendricks and Heller together indicate that you can commit someone for intellectual disability, even though that's not a mental illness.
Would you address the consolidation issue?
Sure. From the state's perspective, we agree with Snyder that the issues in the two cases don't really have anything to do with each other, that a decision in one doesn't affect the other. If you'd like to consolidate them for purposes of a single opinion, that would be fine with us, but...
Well, here's why they might have.
Okay.
And I want to draw your attention specifically to the period of time from November 23rd, 2016, when in the competency proceeding, the district court ordered the state to commence commitment proceedings, and February 21st, almost 3 months later, when the state finally commenced commitment proceedings. Now, it seems to me that the representatives of the state in each separate case are going to want to point fingers at the other side. But we've got 3 months here, and he's confined. And in the habeas case, I presume the argument's going to be, well, the court ordered commitment proceedings. And in the commitment case, the argument's going to be, well, we didn't start the case didn't start till February.
Well,
What do we do with that?
Sure. Well, the statute doesn't give a timeline for filing. I mean, it says the district court shall order the state to initiate commitment proceedings, but doesn't give a timeline, 3 months.
So we force Mr. Snyder to file a habeas petition in the interim, which is in fact exactly what happened here. I mean, is that your response?
To the extent he's complaining about that 3 months time, I'd say that's now moot because he's been involuntarily committed. And again, there's no timeline. So even assuming, and I think as I read the statutes, you can hold someone at least for a reasonable time while the state is preparing the involuntary commitment proceedings, especially since KDEBS isn't always necessarily involved in the criminal case. At that point, it could take them a while to put together a petition, for instance, and that sort of thing. But even if you assume that 3 month period was too long, he's been involuntarily committed as the law allows. So that error, if any, is now, I mean, there's nothing to be done about it. It's moot. And finally, as to Snyder's last point about the fact that he can't be treated, again, the same issue was raised in Hendricks. The Supreme Court rejected it there. They said that they've never held that the state the Constitution prevents the state from holding someone who's untreatable. And also here, there is some form of treatment, whether you consider it treatment or not, according to the expert's testimony, some available services that can be provided to Snyder.
Management
Training.
was the wording of the expert, wasn't it? These conditions can be
I think she used life skills training was a phrase I remember seeing somewhere in the record. And I would note one of the cases that Snyder cites, somewhat ironically, is Youngberg v. Romeo. Snyder cites that for the claim that you have to provide treatment. But Youngberg itself involved a case of a mentally retarded individual. And the Supreme Court there said the state had to provide mentally adequate training or rehabilitation is the term the Supreme Court used there. So there can be services provided, whether they won't cure the intellectual disability, but there are services that can be provided. Finally, just in terms of Snyder's complaints about the ongoing competency exams in his criminal case, Snyder doesn't cite any basis for concluding that would somehow prevent an involuntary commitment case. In fact, the U.S. Supreme Court's decision in Jackson v. Indiana, which Snyder cites, actually reaches the opposite conclusion. In footnote 25 there, the Supreme Court, after finding a due process violation from prolonged competency proceedings, notes that the state can still pursue involuntary commitment proceedings under its procedures. So even if, again, the state doesn't believe there was any error in the competency process, but even if you do conclude there was, that doesn't prevent the involuntary commitment here. Unless there are any further questions.
Where does this leave us in your view then?
With respect to this case, we think you should affirm the decision of the district court involuntarily committing him. Now, there are periodic reviews under the statute. Every 3 months initially, then it turns to 6 months. The state needs to continue to prove that he remains dangerous. And so if his condition were to improve, he can raise those in those cases and appeal from those cases. But in this case, there was, again, he doesn't challenge the sufficiency of the evidence, and his constitutional challenges don't have any merit, so you should affirm the district court.
Any further questions? Any further presentation?
I don't think so. Thank you.
Thank you, counsel. Thank both of you for your arguments this morning. Court will take this. Counsel, you're approaching the lectern. Are you anticipating you reserve time for rebuttal?
I did. I apologize.
Very well, thank you. That concludes the presentation. The court will take this matter under advisement. Now